Jay Kreiner, and my product and business is the Bev Buckle. I am seeking $50,000 in exchange for 10% equity in my business. The Bev Buckle is one of the most interesting inventions America has ever seen. Picture this. You're at a sporting event, a concert, fishing at the river, and you feel the need to free up your hands of your beverage. Ba-bam!
Oh my God.
Oh man.
Oh, that is a great idea.
It's the only buckle on the market that can fold out to hold your beverage. Did Christmas come early? Yes, it did. Everyone knows someone who would want one. I could design the faceplate to have any brand, any logo, and any color. Licensing, branding. So keep that cold beverage close and those hands free because it's the Bev Buckle. Ba-bam!
Bam, baby.
How did you come up with this idea?
I was in college, and I'm out with my friends a lot, and we went to bars, having some good times, and I just, out of habit, I kept doing this, and I thought to myself, man, if I could just hold my beer, hands-free, I could maybe show off my poor dance moves, or...
So, I'm gonna go to Matt first.
Bev Buckle. All right.
Bev Buckle.
Well, a couple different thought processes here. So, one, the name in my mind, I mean, you tell me your product's called Bev Buckle. I know exactly what that is, which is always a red flag, right? I'm thinking merely descriptive.
What's wrong with that? Walk me through it. What's wrong with that?
Yeah. So if a consumer can instantly identify what the product is based on the name, right, without any use of imagination, then the trademark is what we would call merely descriptive, meaning that there's no imagination needed to connect the product or the service to the mind of the consumer. So in this case, like Bev Buckle, I'm like, man, this is one of two things in my world. This is a belt buckle that holds a beverage, or like it's a belt buckle that can open a bottle, right? It's one of the two. It can't be anything else, and it is what it is. So it's descriptive. So the USPTO, I'm looking really quickly at the applications here.
Like 1 minute. Yeah.
But they registered because they filed what's called a 2F amendment to their application, or a 2F application, meaning that they've been in use for at least 5 years, and they can attest that they're the only ones using this product name, and people have come to know them as the source for these beverage belt buckles. So they got the registration with the caveat that it's only because they've been using it for 5 years continuously.
That is awesome. That is a cool example of sort of that secondary meaning. Is that what that is?
Yeah, that can save a lot of clients, especially clients obviously that have been around for a while and they might have a pretty descriptive trademark. We can sometimes finagle it so that we can get through the application process with the descriptive trademark using a 2F claim.
Right on. When he said invention, he went on and later in the presentation and did say he had a patent. He wasn't lying. Let me just show that off real quick and get patent nerdy a bit. They do have his U.S. patent granted in 2012, so a while ago.
Oh, nice. He actually used the term patent correctly, because a lot of times they say, I have a patent. It's like, well, you have a provisional patent application, or maybe you filed a non-provisional application. That's one of my favorite things that also just grinds my gears. It's one of
The truth is, you're actually probably right. During the film, this may have been a 2009 or 2010 pitch to the Sharks, and it was still pending. He didn't know that he would actually get to the finish line. But he did. In 2008, you can see down here, he filed a provisional.
Yep.
Okay, you find that kind of there in smaller print. So he's got 20 years, correct me if I'm wrong, from that date, from the 2009 date. So it's still in force until to 2028 or 2029. And it isn't just on the way that it looks. They got a utility patent. And a brief look. Dylan, I'd love to get your feedback, actually. You got to scroll to the bottom to see what indeed they actually own, right? It's a buckle. Darn buckle. It's a device claim, looks like. You got to have a back plate, a fastener, a front plate, a single hinge, and a stop. Sounds like some parts and pieces. So, I think it's good to see a structural claim. Looks like
Yeah, it's good they were able to get claims on the actual device itself. So that's gonna be good in terms of infringement. So one thing I was gonna say, if it was something that hadn't been filed on yet, I say, hey, you'd want to think about a couple things. One is filing on the device itself. But if that's going to be difficult, a lot of times it can be good to file on a method of use because it can be a lot harder to find prior art on the method of actually using something. Because if you just have that thing, examiner's gonna say, well, it doesn't matter whether this is on a belt buckle or not. What really matters is, this specific thing, and could look at just general drink holders like in a car or something, right? Yeah, right. And that's always a problem, So it's like, it can be helpful to go in with method claims, say, a method of using and, putting on a belt, and then how you, uncouple, undo it and put a bottle in it. It's going to be a lot harder for an examiner to reject something like that. So that could be a sort of a way to, guarantee or, get closer to guarantee getting some of the issue. But it's awesome they would get system claims on this.
Right. Yeah. And David, I think, is on point here. A lot of these folks pitching on Shark Tank, it's a single product and they're trying to call it a business. I think that may be one of the issues. And they did talk about sales. He was able to sell $4,000 worth of the product before pitching to the Sharks. They went back and forth. Barbara actually said she would put in $50,000 for 51%. Okay. But after kind of behind closed doors, she ended up backing out, perhaps after doing some diligence. The huge upside good news is that they're selling $1 million worth of these every year. Wow. They're listed. They have their own website. They're on Amazon. I was blown away. So
this is one of those novelty products. I have a couple of clients like this that sell something actually they're beverage related, and they kill it on these products.
There's the America. I mean, that you can just see the logo. So having a utility patent like that, you're not limited in terms of what types of designs to put on there. The way that the ornamentation, right? You're not locked in. It's just a functional term that has those 4 or 5 elements that we talked about. Any competitor or infringer will be unable to, right, use that, put that into the market.
So, JD, when does this patent expire? When are you and I going to get in on this Bev Buckle?
Yeah, wait a few more years. Look like 2028 or 2029.
I'll be ready. I'll be ready.
It's on my Outlook calendar now. I'm ready.